Imagine two college buddies at Cornell University. This is back in the late 1940s. Just a couple of young guys, scraping by, dreaming big about what's next.
Hmm.
One of them is a man named James McLemore. He's the guy who would go on to found, well, a little empire you might have heard of called Burger King.
Right.
His close friend is Carl Ferris. And Ferris would eventually found a company called Family Dining.
It sounds like the opening scene of a feel-good biopic about the American dream.
It really does start that way. So fast forward to 1963. McLemore's burger business is taking off, and he decides to cut his old college friend the deal of a lifetime. He gives Ferris what we could call the holy grail of franchise agreements.
Okay.
He grants Ferris exclusive rights to build Burger Kings in Bucks in Montgomery counties, Pennsylvania. And the term for this exclusivity, 90 years.
90 years.
Okay.
That's an extraordinarily long time in the world of commercial contracts. In business terms, that's effectively a century-long monopoly on a prime territory.
Exactly. It's a total sweetheart deal born out of a real friendship. But there's a catch. Or, there was supposed to be. Decades later, that relationship sours. Burger King tries to kill this contract because Ferris was late building a few restaurants.
Ah, there it is.
And that brings us to the central legal problem we're tackling in this deep dive. Can a multi-million-dollar corporation suddenly demand strict punctuality after years and years of saying, hey, it's cool, don't worry about it?
That is the pivotal question. Today, we're dissecting the case of Burger King Corp. v. Family Dining, Inc. from 1977. We're going to examine how courts look at contracts, specifically the difference between promises and something called a condition subsequent. And most importantly, we'll analyze the doctrine of waiver through conduct and the equitable protection against forfeiture.
Okay, let's unpack this. Before we even get to the burgers and the lawsuits, we need to understand the tools the court is using. So this first big concept is the structure of the deal itself. When Ferris signed that paper, was the requirement to build 10 restaurants a promise? Like a duty he had to fulfill, or was it something else entirely?
This is a subtle but absolutely massive distinction in contract law. The court had to decide if this was a promise or what we call a condition subsequent.
A condition subsequent.
Right. The general rule for a condition subsequent is that these are words in a contract that don't in themselves create a duty or a promise. Instead, they act as a kind of switch, a trigger that modifies or even terminates the right to enforce a promise.
So a promise creates a legal obligation to do something. If I promise to pay you, I have to pay you, right? And if I don't, you can sue me for damages. But a condition doesn't create a duty.
Correct. The key element here is that the failure to perform a condition defeats the liability of the promiser, in this case, Burger King's duty to provide exclusivity. But it doesn't necessarily mean the other party, Family Dining, has breached the contract. It just turns off the benefit.
Let's apply that to the text of the agreement. The contract said Family Dining gets exclusivity for 90 years, provided that Ferris builds 10 stores in 10 years. How did the court read that, provided that language?
The court found this was a clear condition subsequent. The exclusivity was the right, the benefit given to Family Dining, the development schedule. That was the condition required to keep that right alive.
So Ferris didn't have a duty to build the stores, meaning Burger King couldn't sue him for lost profits if he didn't.
Exactly. But if he failed to build them on time, the switch would flip and he would lose his 90-year exclusivity.
Okay, that sets the stakes. If he misses the condition, he loses the prize. But that leads us right to the second major concept here, waiver and estoppel. This feels like the cool teacher scenario to me.
How so?
If I turn in my homework late 5 times and the teacher says no problem, can she suddenly fail me for being late the 6th time with no warning?
That is the exact intuition behind the rule of waiver by conduct. The general rule says that if a party's actions indicate that literal performance won't be required, they can't, without very clear notice and a reasonable time to fix things, suddenly demand literal performance.
It's just about fairness, right? You can't set a trap for someone.
Precisely. The core element here is protection against surprise strict enforcement. If you lull the other party into believing deadlines are flexible, the law stops you from snapping the trap shut the moment they rely on that flexibility.
To really lock this in, let's use a high-stakes, kind of visceral hypothetical. Let's call this scenario the oxygen tank subscription.
Okay, go on.
Imagine a deep-sea diver. We'll call him Deep Sea Dave. Dave's working on the ocean floor, and he pays a monthly fee for an airline connected to a boat on the surface. The contract is super strict. It says, Airflow's provided payment is received by 12:00 p.m. on the 1st of the month.
A literal life or death condition.
Exactly. So in January, Dave pays at 12:05 p.m. 5 minutes late, the boat captain takes the money, keeps the air pumping. In February, Dave pays at 2:00 p.m. 2 hours late. Again, the captain accepts it. Air keeps flowing. Dave is thinking, okay, the captain's pretty chill. He's not a stickler.
Dave is relying on the captain's conduct. He's being lulled into a sense of security.
Oh, right. Now, March comes around. Dave pays at 12:01 p.m., just 1 minute late. But this time, the boat captain, who decided that morning he just doesn't like Dave anymore, cuts the airline. Immediately, Dave drowns. Or, gets the bends. It's a total disaster.
That is a perfect, if grim, illustration of waiver causing forfeiture. Because the captain accepted late payments before, that's a waiver cutting the line at 12:01 p.m. without any warning, is a grossly unfair forfeiture. The captain waived the right to strictly enforce that 12:00 p.m. deadline.
So the law would step in.
Yes, to prevent the death of the diver, or in our commercial case, the death of valuable business rights, the condition of timely payment is excused.
That brings it home. You just can't cut the airline like that. Okay, let's take that logic and apply it to the actual case. Let's analyze Burger King v. Family Dining. First, what are the legally dispositive facts?
All right, so here's the landscape. We had the 1963 agreement. Exclusivity for 90 years if 10 stores are built, one per year. Stores 1, 2, and 3 opened, though a couple were slightly late. No big deal was made.
Okay.
Then we hit a snag. Stores 4 and 5 were significantly late. Store 4 was 14 months late, and Store 5 was a full 19 months late. Crucially, Burger King granted a formal modification. The founder, James McLemore, explicitly testified that strict dates didn't matter to him as long as there was, and this is a quote, orderly growth.
So the head honcho, the founder himself, basically said, don't worry about the calendar, just keep building. But then things changed.
Yes. The corporate atmosphere shifted completely. Burger King was bought by Pillsbury. McLemore was replaced by a new executive, a guy named Arthur Rosewall. Management became, more corporate, less personal.
And they saw the value in that territory.
They saw a gold mine. They realized that Bucks and Montgomery counties could support way more than 10 stores. They wanted that territory back. The default then happened when stores 9 and 10 were not opened by the final deadline in May 1973. Burger King immediately sued for a declaratory judgment to terminate the exclusivity.
They saw their chance to cut the airline. So with those facts on the table, what was the core legal issue?
The issue is this. Can Burger King enforce the termination provision to end the exclusivity because of the failure to meet that 10th-year development schedule, given their prior history of accepting late performance and the founder's own statements?
And what rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements for us.
The court applied the doctrine of waiver estoppel and, very specifically, it invoked the Restatement of Contracts, Section 302, which deals with the excuse of a condition. The restatement rule here has two cumulative elements. A condition may be excused if, first, its enforcement implies extreme forfeiture or penalty.
Okay, extreme forfeiture.
And second, the condition forms no essential part of the exchange for the promiser's performance. Both have to be true.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply that first element, the concept of extreme forfeiture?
Let's do a little mini IRAC on forfeiture. The sub-issue here was, would losing the exclusivity right actually constitute a forfeiture for family dining?
I mean, it seems obvious.
It does, and the court's analysis agreed. It focused on the investment. Family dining had assumed huge risks and invested a ton of capital to build 8 successful restaurants. The court noted that the promise of 90-year exclusivity was the whole inducement. It was the prize that got Ferris to take on all that risk in the first place.
Right.
So the conclusion on this element was a clear yes. Terminating the contract now would strip family dining of the very benefit they had worked for over a decade. It would be seizing the value of their risk-taking. That is the definition of an extreme forfeiture.
Understood. It's like taking away the championship trophy after the team already won 8 out of 10 games just because they were late to the field for the 9th. Now, what about the second element? Did the condition form an essential part of the exchange?
Okay, here's the mini IRAC on the essential exchange. The sub-issue was strict adherence to the exact dates really essential to Burger King's side of the bargain?
The heart of the matter.
Exactly. For the analysis, the court just looked at Burger King's own conduct. For restaurants 4 and 5, delays of up to 19 months were tolerated without issue. McLemore, the founder, testified that his primary goal was orderly growth, not hitting a specific date on a calendar. The company was still getting its royalties. It was still profiting.
So they were getting what they wanted.
Right. The conclusion was that the exact timing was not essential to the exchange. What was essential was the development of the territory, getting those stores built and operating. Since family dining was achieving that, the condition of strict timing was deemed non-essential.
So the dates were just guidelines, not the main point of the deal. Let's touch on that waiver element quickly as well. How did the court analyze the history of delay and the lack of notice from Burger King?
This is critical for that surprise factor we talked about. So the mini IRAC on waiver notice.
Yeah.
The sub-issue was, did Burger King give clear notice that they were switching back to strict enforcement before they tried to pull the plug?
Then did they?
No. In its analysis, the court said Burger King treated the contract like a hot potato. They sent a letter, the Donaldson letter, that pointed out the delay, but it sounded like a routine checkup. It asked for extenuating circumstances, which is not the language of a termination threat.
It's not a final warning.
Not at all. And what's more, they continued to negotiate with Ferris for months while he was actually starting construction on the 9th store. So the conclusion was that Burger King acted unreasonably. They declared termination without clear, unequivocal notice and without giving a reasonable time to cure the default, especially after having waived similar defaults for years.
It sounds like Burger King was trying to have it both ways, acting casual while secretly preparing to sue. And after analyzing all these elements, forfeiture, essential part of exchange, and waiver, what was the court's final conclusion?
The court ruled decisively in favor of family dining. The condition of strict timing was excused to prevent forfeiture. The contract remained in full force. Family dining got to keep their 90-year exclusivity.
A huge win for the little guy. Or at least, the smaller guy in this fight.
Indeed. It's a powerful affirmation that you cannot lead a business partner to believe that deadlines are flexible and then use those same deadlines as a weapon to seize their investment.
This is such a complex area of law. You've got promises, conditions, waivers, equity. It's all mixing together. For the listener who wants to be able to spot these issues, maybe on an exam, how do you synthesize all this?
I put together what I call a contract termination and waiver checklist based on this case.
Yeah.
If you're ever looking at a situation where one party wants to terminate a deal because the other party missed a deadline or failed the condition, just run through these 4 steps.
Okay, let's hear it.
Number 1, classify the clause. Ask yourself, is the requirement a promise, which creates a duty, or is it a condition subsequent, which acts as a switch to cut off a right? In this case, the schedule is a condition subsequent.
Step 1. Got it.
Number 2, check for divisibility. Is the contract one giant whole deal, like the 90-year term here, or is it sliced into independent parts? If a court sees it as one entire contract, they're much more reluctant to just terminate the whole thing.
Makes sense. What's number 3?
Number 3 is to audit the history, the waiver test. This is the Deep Sea Dave step. Has the enforcer accepted non-compliant performance before? If the answer is yes, you have to ask. Have they provided clear, unambiguous notice that strict compliance is now required? If there is no notice, they're likely stopped from terminating. You cannot pivot from it's cool to you're fired overnight.
And the last step.
Number 4, the forfeiture safety valve. Restatement section 302. Even if there was a technical breach, you apply this equity test. Will termination cause a massive loss of investment, a forfeiture? And was the breach term non-essential to the core deal? If you can answer yes to both of those questions, a court will very likely excuse the breach, to be fair.
That is a powerful toolkit. It really highlights that contract law isn't just about the words on the page. It's about the relationship and the history between the parties.
Absolutely. The law recognizes that real business relationships are messy. They evolve. And the law values consistency. If you want to enforce the letter of the law, you have to live by it from day one or give very fair warning before you go back to it.
So the final takeaway here is pretty simple. Even if you're late to the party, if the host let you in late the last 5 times, they can't just lock the door on you today without telling you the rules have changed.
Precisely. The law values consistency over sudden strictness. You can't use a contract as a trapdoor.
And on that note, we'll close the book on Burger King and family dining. Thanks for diving deep with us. We'll see you on the next one.